Hi Keller Williams family, this is Ron Almberg, your friendly designated broker. And again, I'm here to just raise the awareness of things that you need to be conscious about when you're engaged in real estate practices with Keller Williams, representing buyers or sellers. And that leads into today because I'm talking about dual agency. Written right in with the Revised Codes of Washington in 1886-060, it spells out what your duties are when you are serving as a buyer and seller agent. Now, keep in mind, those that are in Idaho and Oregon, licensed in Idaho and Oregon, you need to be aware of those state laws in those states as well. But here in the state of Washington, this came up in our audits this last fall. We had 2 audits. And this was raised to a whole new level in our conscience here in Keller Williams. So here you go. The first thing is you need to make sure that you have a written agency agreement with both the buyer and the seller. That's state law. You have to have it written. You can't have it a presumed agency agreement with either client when you're a dual agent, right? And it's written right in the law there that you're going to have a written consent of both parties to the transaction. So you should have that in your legal forms provided to us and uploaded into your firm file. And that's going to mean that when your file is audited and looked at for compliance, that we're going to see both sides of the transaction properly documented there, right? And if there's any other duties that you have as an agent representing either party, you need to make sure you have those in writing. Don't assume because you had a verbal agreement with somebody. You need to make sure, put that in writing and include that in your firm's transaction file as well, right? Same duties that were for the seller agent or for the seller or for the buyer apply here. The duty of loyalty, right? Not taking adverse or detrimental action against either party, right? Timely disclosing conflicts of interest, advising both parties to seek expert advice that's outside of your area of expertise, right? Not disclosing confidential information to either party. This puts you in a very unique position as a dual agent, and you need to be aware of that. Your liability goes to a whole different level, and it could come back and haunt you if you haven't taken due care and precaution in serving your clients. So I hope this helps you out. I hope this raises us to a whole new level of awareness in your mind. If you have any questions, do not hesitate to seek out one of our managing brokers or myself, and we will be more than happy to help you walk through that and think through that. Thank you so much.